Good morning. Welcome to the fourth session of the UMSAILS UAP International Virtual Conference on the impact of COVID-19 pandemic in the legal field. I'm MD Sajjad Hussain, lecturer of law, University of Asia Pacific. We have two distinguished panelists today with us. Professor Dr. Ridwanul Haq is a professor of law at University of Dhaka, and currently he's also a ISH Al Walid Research Fellow at University of Edinburgh. And our second panelist is Barrister Imran Abdullah Siddiq, Advocate, Supreme Court of Bangladesh. In this session, we'll have four papers presented by participants. The first paper will be presented by SM Amanullah Aman and Rubaiyat Jamila Manobi, both are from the University of Asia Pacific. On the title of the paper is Labor Law and the COVID-19 Situation in Bangladesh. Second paper will be presented by Padma Richel. She is from Department of Law and Human Rights, University of Asia Pacific. The paper titled on Impact of COVID-19 Pandemic in the Right to the Food and Regional Food Security of South Asia. The third paper will be presented by Bushra Haq, Department of Law, University of Dhaka. A topic on labor law in Bangladesh and India during COVID-19, a critical analysis. And the last paper is presented by Tanvir Ahmed Fahim and Maruf Hassan Tamal. They are from Department of Law, University of Dhaka. And the title of the paper is Balancing Conflicting Public Interests in COVID-19, how the state parties uphold certain right over others. So this session, the whole session will be moderated by MD Rizaur Rahman, Assistant Professor, Department of Law and Human Rights, University of Asia Pacific. Now I'm requesting Mr. Riza to take over the session and start the session. Yes. Mr. Rizaur Rahman, can you hear me?
Yes, I can. Am I audible to you?
You are.
Yeah. Thank you, Mr. Sajjad Hussain. So let me welcome you to the fourth session of UMSAILS UAP International Virtual Conference on the impact of COVID-19 pandemic in the legal field. So I'll be moderating today's session. So good morning to the respected panelists, presenters, colleagues, guests, and the students. So at the beginning, let me give you a brief about the progression of today's conference so we can keep track with our time. So first of all, I'll be calling the four presenters to present their paper. They'll have around 20 minutes to present their paper. And afterwards, our respected panelists will give comments on the four papers to be presented. They'll have around 15 minutes to comment on that. And afterwards, we'll have a question, answer, and comment session where the audience, guests, researchers, and the students can participate, ask question or ask for clarifications. So some housekeeping rule before I call the first presenter. So I'll be requesting everyone to keep their mic muted while the presenter will be presenting. We'll have enough time to ask questions. So I'll be requesting everyone to take note of the question. We're not taking questions from the chat box. So I'll be asking you to, take note of the questions. And to the presenter, I'm requesting you to keep your cameras on while you're presenting, unless you have any technical issues. So these are the few rules. And I'll be humbly requesting, since this is live session, so please keep your cameras off or muted when the presenter is presenting. So without further ado, I'll be calling the first presenter. So the first paper is authored by two authors from University of Asia, Virtual Law and Human Rights, University of Asia Pacific. One SM Amanullah Aman and Rubaiyat Jamila Manobi. Their topic is labor law and COVID-19 situation in Bangladesh. So now I'll be requesting Rubaiyat Jamila Manobi to present her paper. Over to you, Manobi.
Thank you, sir. Am I audible? I'm sorry, my internet is causing a lot of problems, so I have joined from my mobile device also.
Yes, you're audible. So you can, use your slide and start the session if you have slides. Thank you.
Yes, I have slides. Thank you. Before starting my presentation, I, Rubaiyat Jamila Manobi, the press speaker, who is going to be presenting my slides for the next 20 minutes, I would like to thank the UMSAILS UAP International Virtual Conference organizing team for gathering all the talented people together and honoring us with presenting, with giving us the opportunity to present us before the honorable panelists and the audiences who are the great personalities and genius minds. Thank you very much. So without further delay, I will start my presentation. Is it visible?
Yes, it is.
So even introducing my topic, I would like to start with repeating the Joseph Joubert, who once said, "Genius begins great work, but labor alone finishes them." So this already gives you the idea what is our topic. So our topic is the labor law and COVID-19 situation in Bangladesh. I, Rubaiyat Jamila Manobi, alongside with my co-author, Isam Amanullah Al Aman, has worked on this paper. At first, our objectives were to find out the compatibility of the existing labor-related laws, regulations in compliance with the current circumstances. And this paper also aims to recommend the probable solutions that may favor the laborers, ultimately contribute to the national GDP. And then our methodology was the researchers will focus on the doctrinal approach. Moreover, both qualitative and quantitative data will be utilized for a better understanding of the subject. Finally, we have also used the existing national and international laws, articles, books, journals, and reports. So the overview is that we are going to introduce, of course, the labor law and our labor situation currently we're facing in this pandemic. Then we are going to talk about the employment status during the COVID-19 and moving to the safety measures during COVID-19. And we will have a critical analysis of the policies and regulations taken during COVID-19 that affects the labor sector. And from here, we will move to the labor rights, which includes the fundamental rights and human rights. And we will also give the glimpse of the international standards towards laborers during pandemic. Then we will conclude with our recommendations. Thank you. So at first, I want to show you a video. Please tell me it is okay or it is not stuck.
I think we can't hear the voice.
There's no sound.
Okay. Can I show this from my? Can I show this from my device?
Yes, you can.
Okay? I'm really sorry. Okay. I'm gonna share the video file. I'm really sorry. There is maybe some technical issues. Can I continue without showing,
Yeah.
or I can show that later?
Yeah, so please keep that and continue.
Okay. Thank you. I'm really sorry for this.
Nice. Okay, please go to your slide and let's read it.
Yes. So for my introduction, what I wanted to say that because this video isn't working, I'm sorry. So the video isn't working. So my introduction was that the economic will of the country got stuck for a while, and according to the survey of Bangladesh Institute of Development Studies, 13% of people became unemployed during this COVID-19, and income ratio reduced at an alarming rate. Furthermore, the government provided incentives at a low interest at different categories, yet the wages or salaries of the workers are still unpaid. Even after 15 years of the enactment of consistency and enforceability of Bangladesh Labor Act 2006 is in question now due to coronavirus. Moreover, Bangladesh has international obligations to uphold the human rights and also be consistent with International Labor Organization conventions and standards. The bottom line is the laborers in Bangladesh are in great danger because of the non-enforceability and non-compliance with the existing laws, and COVID-19 makes it worse. So moving on to my next point, which is employment status during COVID-19. And I have classified it into two segments. The first one is wages, and the second one is layoff and retrenchment profit policy. So the impact of COVID-19 on the labor sector in Bangladesh, as well as all over the world, is immeasurable and devastating. As a result of complying with strict lockdown rules, shutting down factories and establishments, the companies and employers were overburdened with cost of establishments compared with their zero income, which eventually affected the wages and jobs of labor. Now moving to the wages, according to the subsection 45 of section 2 of Bangladesh Labor Act, wages means all remuneration capable of being expressed in terms of money which is payable to a worker if the terms of the contract or employment are fulfilled. The term also includes economic benefits like salary, any bonus, remuneration for overtime work, leave or holiday, termination of employment, or other additional remuneration payable under the term of employment. The wage period shall not exceed 1 month, which must be paid before the expiry of 7th working day, which after the last day of the wage period. If the employment of a worker is terminated by the retirement or by the employer through the retrenchment, discharge, removal, dismissal, or otherwise, the wages payable to him must be paid before the expiry of the 13th working day from the day on which his employment is terminated must be paid on a working day. And there can be no deducting made from the wages of a worker. And the minimum wage rates are declared by the government on an industry basis following the recommendations by the Minimum Wages Board, a special tripartite established under the Labor Act. So the declared minimum wages are final, neither be questioned, and nor any employer can pay wages lower than those notified by the government. The minimum wages, the minimum rates of wages for any industry may be refixed after every 5 years, as may be directed by the government. So now moving on to the statistics, even after refixing minimum wage in 2018, the Japan External Trade Organization, a survey report said that it was still the lowest cheap labor in the global standard. So if we look at the percentages, so I'd like to say that the vulnerability of labor got worse after the outbreak of COVID-19. The wages for daily and salaried workers declined by about 37% compared to earning before the outbreak. The decline was higher in slum areas as of 43% than non-slum areas as of 33%. The scenario is similar as in Dhaka compared to Chittagong, respectively 42% and 33%, which means wage declines of Dhaka larger than Chittagong for both genders. The research by Subir and Malini Choudhury for the Center for Bangladesh Studies, UC Berkeley, in collaboration with the Institution of Human Rights and Business, the paper also says that the industry suffered from a closure of markets, suspended shipments, delayed payments, and liquidity crisis. Bangladeshi workers suffered what was in effect a 35% pay cut during the lockdown month. However, if any employer cannot ensure minimum wages for his workers, there is an option to bring him to justice by seeking proper remedy to the labor code. However, in Bangladesh, low productivity is the main plea of the employers in support of non-payment of minimum wages. Now moving to my next point, which is layoff and retrenchment policy. So layoff means the failure, refusal, or inability of an employer to give employment to a worker on account of shortage of coal, power, or raw material, or accumulation of stock, or the breakdown of machinery. Though the definition did not consider the pandemic of like COVID-19 as a ground to lay off, however, an employer may, at any time, if necessary, in the event of an epidemic or any other cause beyond his control, stop any section or sections of his establishment. In addition, the period of the stoppage of work exceeds 3 working days, the workers concerned shall be laid off in accordance with the provisions of Labor Act. Upon laying off any worker, the employers must pay the compensation for those whose name is on the master rolls and who has completed 1 year service. The amount of compensation and the payment of compensation for more than 45 days is also prescribed in current Labor Act. However, if a worker is to be laid off after the first 45 days, as aforementioned, for many continuous period of 15 days or more, the employer may, instead of laying off such worker, retrench him under the provision of labor law. So the employer can terminate a worker under the ground of retrenchment if only where a worker has given 1 month's notice in writing indicating the reason of retrenchment, or the worker has been paid in lieu of such notice wages for the period. A copy of the notice in respect of retrenchment has been sent to the chief inspector, and the worker has been paid at the time of the retrenchment, compensation or gratuity, whatever it is required. So now moving to my next statistics. So the employer can, so the average 68% of workers seem to have experienced losing a job, and which is higher in Dhaka than Chittagong, respectively 76% and 59%. And the slum areas also show higher termination as 71% than non-slum areas at 61%. The research report also reveals a huge number of laborers were terminated or laid off without their consent or compensation. Moreover, the report shows any Bangladeshi factories supplying international brands consolidated their business, and some went under, which led many workers to lose their jobs without having a safety net to fall back on. Now moving to my safety measures during the COVID-19. So the Chapter 5 of the Labor Act of 2006 briefly discussed about how to maintain the health and hygiene in a workplace. All the necessary measures have been already prescribed, however, except personal protection equipment, which includes masks, gloves, PPE. Another thing to add with the labor law is to maintain the social distance as per the guideline of the WHO or World Health Organization, which suggests keeping a 3-meter distance from each other, and so does the Bangladesh government. However, Section 56 of the Labor Act talks about the overcrowding place, that no room for work in any establishment shall be overcrowded to extent that injurious to the health, and the allocated space should be at least 9.5 centimeters. Nonetheless, all the establishments do not comply with this provision. However, social distancing is one of the most effective ways to spreading coronavirus. Now here, I want to throw a question to the audience. Are the workers actually allowed to use PPE while producing them for others? And I have also talked about the daycare center, because according to the BGMEA, the Bangladesh Garments Manufacturers and Exporter Association, around 3.2 million women are the workers who are 8% workers employed in BGMEA's member factories. So it is obvious that the women need to take their children with them, and the section the section 94 of the Labor Act also talks about having a daycare system. But how many factories actually following them are actually in question. Then moving to my next point, which is critical analysis on policies and regulations taken during COVID-19 that affects the labor sector. So at first case of COVID-19 reported, from the very beginning, the government is trying to mitigate the crisis that occurred due to this pandemic. Moreover, the government provided assistance door to door for the poor and established a new medical setup to tackle coronavirus. However, according to the Asian Development Bank, the population living below the national poverty line reduced 20.5% in 2019 from 24.3% in 2016. However, on 4th June 2021, the Daily Star reported that COVID-19 creates 2.45 new poor. So the increasing rate of COVID-19 patients and comparison of the data of ADB with the report of Daily Star indicates that the prescribed measures taken during this pandemic are not adequate. It started with general holidays, close of the educational institutes, lockdowns, travel bans. But those are timeless and much required decisions by the government. But the continuation with the lockdown, people started to become jobless, and hence people need to earn livelihoods for their survival. Then I'm going to move to my next point, which is the fundamental rights and human rights of laborers during pandemic. So A fundamental and human rights-based assessment regarding the impact of the pandemic on workers' rights need to be undertaken. The Constitution of Bangladesh envisages an array of the welfare actions for workers, including wages, recreation, reasonable rest and leisure, rights of forming union, protection from uh, all forms of forced labor, and protection from all forms of exploitation. Moreover, Bangladesh has ratified 7 of the 8 core conventions and several other conventions of the ILO, or International Labour Organization. Furthermore, the ILO Declaration on Fundamental Principles and Rights of Work, 1998, introduces 4 core labor rights, and one of them is the elimination of discrimination in respect of employment and occupation. So, in spite of constitutional and international commitment and obligations, human rights of the workers are being constantly violated. Moreover, clear directions are given in the Universal Declaration of Human Rights, or UDHR, and ILO conventions for payment of reasonable wages to the workers, which must be ensured by law, as well as actions have to be taken against those who fail to implement the law. In addition, it cannot be left in the hands of anybody's discretion. According to the UDHR, a worker has the right to just and favorable remuneration, ensuring for himself and his family as an existence order of human dignity and supplemented. It also adds that everyone has the right to standard of living adequate for the health, well-being for himself and his family, including food, clothing, housing, and medical care, and necessary social services, and the right to security. And also, the UN Guiding Principles for Business and Human Rights provides comprehensive guidelines to integrate human rights perspective into business policies and practices. However, the Labor Act of 2006 provides unfettered power to the employers in many cases, while many workers immensely vulnerable and dependent. Though in its latest amendments of Bangladesh Labor Act prohibits
Just to interrupt you, Rubaiyat, you have around 5 minutes to conclude your presentation. Thank you.
Thank you very much. The number of child workers are getting skyrocketing in number due to COVID-19 induced the economic crisis and nationwide closure of the educational institutions. So no further delay, I will move to the next point, that is international standards towards laborers during pandemic. So I have just taken some of the points. So the International Labor Organization follows international labor standards because it has grounded the use of an integrated approach for responding to the COVID-19 crisis, aiming at mitigating the socioeconomic implications of the pandemic and helping countries to recover from it. So my first point would be the sustainable minimum wage is relevant in an economic downturn, as minimum wages can safeguard the workers in a vulnerable condition and decrease poverty, increase demand, and contribute to economic stability. In addition, the wages shall be paid regularly, and upon the termination of a contract of employment, a final settlement of all wages due shall be effected as prescribed, or if not specified, within a reasonable period of time. Then moving to the next point, that the workers whose employment is terminated because of health and safety reasons or the economic impact of COVID-19 should be allowed a severance allowance other than the parting benefits, unemployment insurance benefits, or aid to compensate for the loss of income incurred as a result of the termination. And the employment of a worker shall not be terminated in the lack of a valid reason for such termination, like temporary absence from the work due to illness or family responsibility. Then my next point is the unemployment benefits has to be provided for the workers, and the next point is that employers have the full obligation of safeguarding all practicable preventive and protective methods to minimize the occupational risk, and the employment benefits are provided for the workers whose earnings are suspended due to absence of suitable employment under such conditions. And then the laborers should be informed about the health hazards involved in their work in an appropriate and adequate manner. The workplace must mandate the workers to report to their immediate supervisor if any in which they have reasonable justification to be certain of an imminent and serious danger to their life or health. The employer cannot require the workers to return to work when there is still continuing imminent and serious danger to life or health. So all the International Labour Organization legal instruments lay down the basic minimum social standards in the global economy, which states may implement with higher levels of protection and enhanced measures so as to better mitigate the impact of the crisis. And now I have collected some recommendations for my presentation from my actual research paper. So the first point is that, and all these recommendations are showcasing the ideas obtained from the international labor standards, because it maintains the opportunities for all to obtain decent and productive work in conditions of freedom, equity, security, and dignity, while adjusting consequences of the COVID-19 pandemic of the socioeconomic. So first, a multi-track approach to enable recovery should include immediate employment and social protection measures promoting and recovering the local economy, then conducting impact assessments of employment on national recovery programs, providing guidance and report on employers to ensure the effective measures to identify, mitigate, and address the risk of adverse impacts on human and labor rights in their services or operations. Then obviously promotion of the collective bargaining and the social dialogue. And then building the labor market institution, including restoring the employment services, promoting sustainable employment and decent work, sustainable development, social protection, and social inclusion, the creation of sustainable enterprises such as small and medium-sized enterprises, the transformation from the informal economy to the formal and environmentally sustainable economy. Government should seek to ensure basic income security like unemployment benefits, especially for jobs or livelihoods of whom have been disrupted by the crisis. So now to conclude my presentation, I'd like to say that COVID-19 has questioned the existence of the laborers and their families' life. Many people have lost their job, and the equation of losing the job is very simple: low productivity and zero income. On the other hand, if the owner's perspective takes into consideration, it is found that the buyers rejected most of the orders due to the pandemic. They are not producing and selling any goods. However, the companies should have collective insurance policies so that the workers can feel safe. And many people are the only earning source for their whole family, like Saleha, which I wanted to show in the video. And the video has elaborated my points in, but I could not show that due to technical issues.
Excuse me, Rubaiyat, I have to stop you now because you're 20 minutes up. So if you have anything to conclude in 10 seconds, thank you.
Oh, okay. Thank you very much. I was already in the end of my presentation. So to conclude, to ensure the fundamental and human rights of labor, the importance of national programs for appropriate actions and measures is immense and must be regulated and monitored under the umbrella of international labor standards. And then I have added some of the references which I have used in my slides. And thank you for your immense support and patience. Thank you very much.
Okay. Thank you, Rubaiyat Jamila Manobi, for your wonderful presentation. So let me now call our second presenter, Padma Rizwal. She's an LLM candidate in Department of Law and Human Rights, University of Asia Pacific. So now I'd invite Padma to present her paper. You have around 20 minutes to finish. Thank you.
Thank you, sir. I'm much obliged to present myself in front of our distinguished panel members, and I'm very thankful to the organizing committee of this conference for giving me an opportunity. So, hello everyone, I am Padma Rizal from Nepal. So the topic of my paper is impact of COVID-19 on the right to food of South Asian people and the need of regional cooperation for regional food security. So, human dignity has always been at the core of the human rights discourse. Because of COVID-19, we are feeling a loss of dignity because we are no more in control of what we eat, how we eat, and when we eat. So right to food as a basic human right, it has been enshrined in many international legal documents, and one of those binding instruments is ICSCR, whose Article 11 obligates the state parties to respect, protect, and fulfill the right to food of people. So further, right to food is not limited to fulfillment of minimum calories or right to be free from hunger. Instead, it is broader than that. And the Committee on Economic, Social and Cultural Right, through its General Comment number 12 on right to food, has further expanded the concept of right to food by adding several dimensions. My right to food, then food needs to be available at the first place, and I need to access that food, and that accessed food needs to be utilized in a manner that I can fulfill my all nutritional need to live an active and healthy life, or a dignified life. So and this committee also tells that there need to be stability and sustainability in our food system, so that all those variables of availability, access, and utilization can be ensured. So coming to the concept of food security is a technical concept which encompasses the legal aspect of right to food. Because when I say a country or a region is food secure, that means people residing there are properly exercising their right to food. Because generally accepted pillars of food security are those same elements. So these are the 4 pillars or prerequisites of right to food. So let me highlight how COVID-19 pandemic has affected all those elements of right to food. So coming to availability, as we know, like because of immobility, lockdowns, and trade restrictions, there has been disruption of food also. So because of this, the total availability or the stock of food in market has not been consistent enough. So also, as we already heard in previous presentation by Ms. Manobi, we already heard how sorry. Oh, so yeah, she mentioned how because of laborers and their loss of job, it has directly affected the overall production of food, which have affected the productivity and availability of food in the marketplace. So talking about availability, also in landlocked import dependent countries like Bhutan or Nepal, because of trade restrictions, the total availability of food stock have been compromised, and this compromise in overall productivity as well as available stock has directly impacted the availability aspect of right to food. So because of the restrictions in
Just to interrupt you,
supply
Padma,
of
we are encountering
input in agriculture such as fertilizers.
Padma, just to interrupt you, we are encountering some lag from your part, I think. So would you please turn off your camera and present, please?
Okay, sir.
Yeah, thank you.
So,
yeah, yes, you may continue now.
Sir, can you see my screen?
Yeah, I can see you. Please continue. Thank you.
Yes, sir. Yeah, so I was telling that because as we know how laborers working in the agricultural sector are sick and they have lost their jobs, and this has overall affected the availability of food because production has been decreased. And because of disruption in supply chain, the total stock available in market also have been affected, due to which these have impacted the availability of food. So coming to access refers to physical, economic, and social access to food. So for me to realize my right to food properly, I need to have proper or meaningful access to that available food. So talking about physical access, because of lockdown and immobility, people are not having direct or convenient access to market at the first place. So coming to the economic access, IMF and World Bank have predicted that predicted global economic recession, and the rising global food price index also indicates that food is no more affordable. And because of job losses and loss of working hour, the total disposable income of consumers have been compromised, and because of this, people are having difficulty to access the food from their economic aspect. So also because of panic buying and hoarding of goods, the prices of goods have been increasing constantly. And also talking about social access to food, the impact of COVID-19 has directly affected the most vulnerable sections of our society. So they are migrant workers, women, children. So talking about children, April 2020 was the peak time when a maximum number of children, school children around the world, they were deprived of their regular school meals. So 369 million children from 199 countries were not being able to access the food provided by their school. So talking about women, women are considered as caregiver or caretaker in their family. So after the COVID pandemic, they are engaged in taking care of the sick family members, and their economic activities also have been seized. So even before the pandemic, because of social inequalities, women were already deprived of nutritious food compared to their male counterpart. So this sums up the access. And coming to the utilization, after COVID pandemic, the spending pattern of consumers have been changed. So the food basket is homogenized within like few staple food, and the highly nutritious food products like dairy product, fish, meat, fresh vegetables or fruits, which are very rich in micronutrients. They are perishable, so they are subject to trade disruption, and they do not reach the market at the first place. So because of the shift towards processed and unhealthy diet and unavailability of nutritious food, the utilization pattern is not nutritious. So so it has affected the nutritional aspect of utilization. So talking about stability, as we saw how the impact of pandemic has directly affected the total availability, social, economic, and physical access to available food, and utilization pattern of food is not healthy and nutritious. So because all those three pillars are taken down, the whole food system is not predictable, so not reliable enough. So this has compromised the stability of our food system, so thus affecting our right to food and how we exercise our right to food. So talking about the analysis through the demand and supply side, this figure is given by Asian Development Bank. So through this figure, we can see how the impact of lockdown is visible both in supply side as well as demand side. For the supply side, the pandemic has affected the overall productivity and reduced the supply. And on the demand side, consumers are having limited access to food, because of which they are not being able to exercise their right to food. So to sum up the impact of COVID on right to food, we saw how the impact of COVID and the lockdown policies imposed by countries have intensified the poverty ultimately. And because the economic aspect, the economic access part of the food security is mostly affected, the rising poverty and food insecurity is predicted by many international organizations such as FAO, World Food Program, UNICEF, and other organizations. So my research was based on the secondary data published by those UN specialized agencies. So coming to the situation in South Asia, most of the countries in South Asia are lower and middle income countries. So the problem is people there were already living just above the poverty line. So after the COVID, they had no financial savings or income cushion to ensure their household food security, because they lack the financial resources to ensure their right to food. And similarly, government in those countries, they lack the financial resources to target the right to food, particularly right to food aspect of people. So their government were not well prepared to provide the social security scheme or immediate relief targeting the right to food of people. So this reason, which is also lagging behind on the sustainable development goals, whose goal two is uh, to eliminate the to reach zero hunger. So this reason is already lagging behind, and further already the problems like poor healthcare, poor social welfare scheme, and child malnutrition, as we can see in the figure. These were already a problem even before. Further, in long run, the food security of this region was. Am I audible?
Yes, Padma, we can hear you clear.
Okay, so the food security of this South Asian region was already affected by internal armed conflicts, refugee problems, and economic shocks, weather extremes, and locust attacks. So they are the major problem which have hindered the realization of right to food in this region. So talking about the existing regional cooperation mechanism, SARC is one of them, and my paper is focused on how we can mobilize the existing regional mechanism to achieve food security or to make countries realize the right to food of people. So before the pandemic in 2019, there was a statement called Thimphu's Statement on Agriculture and Rural Development 2019, which had addressed about ensuring food, nutrition, and livelihood security. So even before the pandemic, they were already working on this area. And after the pandemic, on the initiation of Indian leader, Prime Minister Mr. Narendra Modi, a COVID-19 emergency fund for SARC countries was created. And even after that, the online virtual video conference of health ministers, trade officers, and planning ministers have been going on, and they are showing a willingness to work together to solve the problem of overall poverty and food security. So they discussed about how to revitalize the regional approach to address the greater problems of poverty, food security, hunger, and health. Similarly, other institutional mechanisms already in place, such as seed bank and agricultural center, they are working very hard to sorry, they are working very hard for agricultural research, development, and capacity building of people working in agriculture and agricultural innovation and all other factors that are responsible for food security. So talking about food bank was, even being an old institution in SARC, it was never operationalized in the first place. Even during the flood in Bangladesh or earthquake in Nepal, this emergency food reserve was not being utilized. But after pandemic in May 2020, Bhutan for the first time utilized this food bank, and it withdrew some grain to address the COVID pandemic needs. So yeah. So the major recommendation of my paper is South Asia, because South Asian countries, they share similar climatic zone, similar climate change vulnerabilities, similar market structure, agrarian structure, and the technology used in agriculture, like labor-intensive technology. Our food culture is similar, our economy is interconnected, and trade is also an important factor in maintaining the stable supply of food in every country. So because of this, we need to South Asian countries need to work together to ensure the regional food security, and to address this the bigger problem of poverty alleviation, agrarian reform, rural revitalization, and retaining the migrant workers who recently returned to their home place by attracting them in agriculture. Like these can be some strategies that South Asian countries can adopt, because if we are to develop or strategize agriculture for poverty alleviation and food security, like it has twofold effect. For example, it can give it can generate employment, as well as it can ensure the constant availability of food by increasing the productivity. So apart from that, providing the social safety nets to the vulnerable section of society, addressing their particular right to food, addressing their right to food is also a necessity. So the policy response for South Asian countries should be directed towards the economic access of people to food, the economic access I talked about. And there needs to be cross-sectoral collaboration to reshape the whole food system, so that the healthy diet can be supported, and people can so that people can live a dignified life. So in future, South Asian countries like they need to operationalize a food bank also, because food bank had many structural and procedural problems. It had ambiguous governance, the pricing mechanisms, transportation, distribution, and even the capacity of food bank in the first place is questioned upon. So this needs to be improved by SARC. And coming to the conclusion, so I think all the legal, diplomatic framework or institutional mechanisms created until now by the SARC needs to be mobilized, and it should be human rights sensitive. The approach must be human rights sensitive, and the right to food need of people must be addressed. And instead of depending upon a supply side or reactionary approach to the COVID, I think a sustainable approach should be pursued. And because of COVID, we came to realize that we live in a virtually borderless world where neighbors need each other the most. So supranational cooperation is necessary. So countries of SARC need to forget about their political differences and come together, work together for resilience and sustainable recovery, and to ensure the right to food of South Asian people. So this concludes my presentation. I'd like to welcome any comments or questions from the panel as well as from the audience. Thank you.
Thank you, Padma, for your very interesting presentation. So far we have two presenters presenting their paper. So just a slight reminder for the audience, so we have a Q&A session after the panel's comments. So please take your notes of your questions. And if you have any comments, please do take a note of them. That will be very helpful for our presenter to improve their paper. So now I'll be asking our third presenter, Bushra Haq, a graduate student of University of Dhaka, Department of Law, University of Dhaka, to present her paper. Over to you, Bushra.
Am I clearly audible?
Yes, you are.
Yeah. Thank you, sir. Good morning, distinguished panelists and all participants and everyone else who is present here. I am Bushra Haq. I'm currently doing my master's from University of Dhaka. So if you could just help me, is my slide present? Is present here?
Yes, it is.
Thank you. So my topic is labor law in Bangladesh and India during during COVID-19. I'll just take a minute because I'm just having some. Okay. There it goes. Thank you. So my title, the topic that I'm going to present today is titled Labor Law in Bangladesh and India during COVID-19, a critical analysis. Starting with a quote, laws are spider webs through which the big flies pass and the little ones get caught, by French author Honoré Balzac. At the end of my presentation, I'm pretty sure you will understand why I use this quote. And with this, I will take your attention to the title, where you can see that I have used Bangladesh and India to work on. Bangladesh, because I am a Bangladeshi, and India, because both India and Bangladesh, they share deeply the same culture and heritage. Before the separation in 1947, they were obligated by the same rules and regulations. However, after the separation in 1947, Bangladesh and India went on their way to development and have undergone drastic changes, which is reflected in the labor sector too. Well, in 2021, you can see the changes in the GDP rise because India was in advance in the line of progress in Bangladesh, but in 2021, in terms of GDP, we can see a down in the GDP's rate in case of India, and where Bangladesh GDP just increased. However, you will see more of this change as I go deep into my paper. Now, the introduction.
Just to interrupt you, could you please keep your cameras on if possible? Thank you.
Yes, sir. One second.
Thanks.
Well, sir, I'll just take 1 minute, sir, for rearrangement. Thank you. So the introductions. So in introductions, I have tried to show the impact of COVID-19 on the socio-economic conditions of the countries and the labor sector. We see that this COVID-19, it has canvassed the inconsistent balance between the workers' right and the economic development of the country. Now that the spotlight is on this labor law, we see that this sector needed this spotlights earlier. And also, with this emergence of pandemic, the urgent enactments of different policies corroborate the fact that this labor law system required reform much longer back. This paper, it further intends to scrutinize the legislations to measure the attitude to govern the present Holocaust. Both the country's government, they have enacted policies to synchronize workers' rights and country's development. The paper further analyzed the country's economic growth and its impact on the workers. However, despite all the loopholes in the labor law system and this devastating impact of COVID-19, we can see that both the country, Bangladesh and government, Bangladesh and India, they have taken maneuvers to sustain the calamity as well as post-COVID period. Now comes to the methodology. I had to depend mostly on the secondary data due to this COVID, and the data literatures and data sets that are available online. I use them to write this content. The objectives of this paper, it aims to describe essential factors affecting the vulnerability of workers, both in Bangladesh and India. It intends to highlight the impact of existing legislation in regulating workers' lives. Based on secondary materials, the paper also shows the reality check of the different initiatives taken by the government, along with few recommendations. This paper, it has its limitations because this pandemic, it is still ongoing, and with changing its variant now and then, I could not reach conclusive decisions. Now comes the laws and regulations. This is the first part of the paper, which seeks to show the competency of the existing provisions in the legislature to deal with the pandemic. The objective is to assess whether and to what degree the existing body of laws is capable of addressing the issues that have emerged as a result of the ongoing uncontrollable situation. Let's deal with the key actors for the maintenance of labor sectors. For this, we are going to take resort to the United Nations Guiding Principles for Business and Human Rights. We know it is based on 3 pillars: protect, respect, and remedy. So in its guidelines, it has said that the state must protect against human rights abuse within their territory or jurisdiction by third parties, including business enterprises. It has also mentioned that this responsibility is to be shared by international organizations and suppliers directly and indirectly. Suppliers directly because they have a direct connection or contact with the workers, and international organization because they have an independent responsibility to respect human rights. And further, as for the union leaders and consumers, we know labor law is mostly focused on an organized labor sectors that include collective bargaining, freedom of association, union leaders. So with this, we can say that these union leaders they have a huge responsibility to pay for the welfare of the workers. And as for the consumers, they can also pay their part by properly fulfilling the obligations that are mentioned in the contract. Now comes to the legislations that maintain the labor law. Well, the Constitution of the People's Republic of Bangladesh and the Constitution of India both have adequate provisions to uphold the workers' right and dignity. They have ensured basic necessities of life, equal opportunity, income inequalities, and then the workers should be free from exploitation, discrimination, stock picking, child labor, and then there should be due diligence in paying remunerations. So in conclusion, you can see that both the constitutions are well equipped to protect the workers' rights. Well, I haven't mentioned the articles because I think everyone more or less knows the articles. These are the constitution. And as for the national legislations, labor laws in India, they are enacted both by the center and state government. Till now, they had 29 labor laws. But the government started codifying them since 2000 and have compiled them to 4 major labor codes. It is needed to be mentioned that they will be implemented once the rules are notified. And this reforms was done to both the economic sectors. So yes, this since the 29 laws are from the colonial period, the step taken to codify these laws were much appreciated. But however, they received few criticism too, as they were just basically the codifications and no reforms. I am not going to talk much about the Indian national legislations, as I say that they have codified them recently, but they are to be implemented are to be implemented by 2021, and the parliament has already passed them, but yet their rules are to be notified. So I'll just go to Bangladesh national legislations, and we will see that if they are well equipped to deal with this COVID-19. We know Bangladesh labor law, Bangladesh has this main labor law regulating the labor law sector, which is Bangladesh Labor Act 2016. It has an amendment in 2018, the latest, and also this Bangladesh Labor Rule 2015. Now, if we move to the guidelines by World Health Organization, which in where we can see that they have mentioned physical distancing, wearing a mask, proper ventilations, etc., as in safety measures. Now, back to Bangladesh Labor Act. We can see that there are provisions on this cleanliness of the entire enterprises, also on maintenance of hygiene and cleanliness in washroom, washing facilities, floors, passages, staircase, bathrooms, and there should be proper ventilations, etc. So when we put this context in, when do we put these provisions of Bangladesh labor law in the context of COVID-19, we can say that in terms of cleanliness and hygiene, Bangladesh Labor Act is well equipped. Then comes to another guideline, important guideline, which is to mention physical distance between 2 individuals. So again, going back to Bangladesh Labor Act, section 56, we see that they have this provision to keep this room, not to keep this room from overcrowded. So if the guidelines are implied to keep this minimum distance between 2 workers or individuals 6 feet, we can say that in terms of physical distance too, Bangladesh Labor Act is well equipped. Now comes to the payment and compensation. Bangladesh Labor Act Section 12, it gives the employers the right to stoppage of work in case of an epidemic, but they have these provisions to compensate the workers too in case of layoff. And further, when it comes to complying with these provisions in the Act, we can say that there are sections in the existing legislatures too. If anyone violates the orders issued to prevent the further spread of the disease, then that person can be punished under Section 268 and 63 of the Penal Code imposed by the Mobile Code Act 2009. So here with these legislations, we can say that the legislations are well equipped. They do not need the reform, but what they need is proper implementation. Now I'm moving to the second part of my paper, which is Bangladesh and India's policy responses. This part, it intends to provide a short but comprehensive review of the initiatives proposed by the legislators in Bangladesh and India in response to the effect of COVID-19. I have to keep them very short because of this word limit and time constraint too. So the pillar, we know that Bangladesh and India, they both enacted policies based on the 4 pillars of actions by the International Labour Organizations. Pillar 1 is stimulating the economy and jobs, which objective is to mitigate the impact of the crisis on economies and labor markets. So till now, Bangladesh has issued 23 stimulus packages of total 1,24,053 crores, and India, it has issued 38,19,584 crores so far. But when targeting the audience, we will see that India has taken initiatives more or less to address every section, specifying it has a more comprehensive plan to address the pandemic than Bangladesh. Well, this we have in my slide, you can see the initiatives taken by the India. They have addressed more or less a lot of sectors, but Bangladesh is confined to RMG, export-oriented sectors, and then this import of raw materials, which is also export-oriented sectors. I'll move to my second second pillar, which is on supporting enterprises, jobs, and incomes in Bangladesh. In these sectors, if you see this slide, we can see the number of people who lost the job. I have categorized them. RMG sector, migrants workers, day workers. It's hard to remember the statistics, so I'm just not going to say them, and rather focus on how these stimulus packages are introduced by Bangladesh is not educated. They have 20 crore stimulus for SME sectors, and for migrant workers, it is 700 crore at 4% interest. However, they left one of the most important sectors, that is the informal sectors. And we know that 80% of the informal workers, are informal. So this stimulus packages of Bangladesh has just opted out this an important sectors. Now, again, if you look at India's responses, we see that they have introduced a lot of front. They have these control rooms, and they have poor pensioners, widows, and dispenses, which cannot be seen in case of Bangladesh. So we will conclude in terms of pillar 2 that governments of India's initiative to secure the income sector is way more detailed than Bangladesh initiatives. Moving to pillar 3, which is on protecting workers in the workplace. Bangladesh governments, they have issued guidelines, 2 guidelines for the workers and the health workers. And when it comes to India, we can see that along with the guidelines, they have these training programs. For front line workers on addressing rumors and actual facts around. That was very important. You will see at the as I go more with my presentations. Then they have also launched helpline on behavior and social psychopath health. So these initiatives of workers to address the mental health is very appreciating. Again, moving to pillar 4, I think Bangladesh stay stronger in this case. This pillar 4, it is on using social dialogue between government, workers, and employers to find solution and to strengthen the capacity and resilience of employers and workers organizations. When to implement this pillar 4, Bangladesh, it can take resort to the universally recognized right, the freedoms of association, the right to organize, and the right to collective bargaining. And for this, Bangladesh provisions are, there are educated provisions in Bangladesh, like Article 37 of the Constitution, Section 176 of the Bangladesh Labour Act, and International Labour Organization Convention Nong 87. But in terms of India, this right is enshrined in Article 19 of its Constitution, the freedom of association, and India hasn't ratified ILO Convention Nong 87. So, as I have mentioned earlier,
just to give you a reminder, sure, you have 5 minutes to conclude. Thank you.
Sir. So when we come to related checks of government initiatives, we can see that there is huge gap between the government's plan in getting the outcomes and also in the relative field. We will see, due to this time constraint, I will directly take your focus to the protest and rallies that the government workers are taking to the streets on daily basis. This explains pretty much how they are being deprived from their due wages, but the government and the authorities, they are speaking otherwise. And in these cases, I will just give a paid benefit to the employer, because the foreign buyers, they're just canceling the orders in giving this force measure excuses. And we know this due to this, the employers, they're at a loss too. So it might not be always possible for the employers to give the due payments of the employees. But also, again, I'm taking your attention to the quote that I have mentioned earlier, that the big flies, they are passing away. So this cancellation of orders are depriving the employers who have middle income, but not the one who are the big fishes. The circumstances in India, it is more or less the same. The government has introduced stimulus packages, but for registered workers. But statistics, it shows that only 95% of the workers are registered. So what is the point of introducing stimulus packages for registered workers when the workers are not getting it? And also there is also this foreign orders cancellations and the second wave, which has just disrupted India's economy. So if we now move to the analyzing government strategy on development during COVID-19, we can say that they have just ignored the basic points that is recently the buzz topic. Like India, it has reformed its laws and codified them, and it has also taken this attempt to make the definition of wages uniform, and also amended the labor workers definitions amended. But in case of Bangladesh, we know that not all workers are included under this Bangladesh Labor Act. But when initiating the guidelines, governments has mentioned that the workers that are mentioned under this Bangladesh Labor Act are to be also protected under this guideline. And then there comes this vaccination thing. There no step till now has been taken to address this vaccination. So the workers, they are just being deprived from getting vaccinated, even though the authorities, they are saying they're trying to get this workers vaccination. Now, if we look at the GDP, we will see that the Bangladesh GDP is higher than India. This might give us the idea that worker situation in Bangladesh is improving, but that's not the case, because Bangladesh economists think that GDP rise from the existing income inequality, which has intensified in this pandemic. Well, the fact that poor are becoming poorer, people are losing jobs, but country's GDP is increasing, just corroborate this economist opinion. It is high time for Bangladesh, this can be a recommendation that Bangladesh needs to understand that growth-oriented policy measures are not sufficient to reconstruct the economy in the post-COVID era. Adoption of employment-oriented economic policies is what Bangladesh needs to create more jobs and reduce poverty and inequality. For India, they have already reformed the act. Now it is time to see if implementations of this four major course could bring changes in their level of system and also increase their GDP. I would like to give more recommendation, which are laws and regulations. I have already talked about it, and uniform definitions of workers and all its related terms are required. Then there comes this awareness on COVID-19. We know that governments at times try to hit the main real statistics, and this is creating fear and concern over the epidemic. The ratio of the suicide cases in both Bangladesh and India shows that this fear and concern is stretching out this stretch COVID-19 further. So in this case, the social media and other leaders can come forward. And for this in case stimulus packages, we have already seen while talking about this pillar that they are not adequate. So government should increase the stimulus packages. And also we have seen that a large number of people are becoming unemployed. Government of Bangladesh has encouraged people, also India has encouraged people to be self-employed. But government, they need to take initiatives to introduce fund in small scales. They need to arrange programs so that this skill level know how to be self-employed. And as for the unskilled labor, job in the labor-intensive public work scheme or short-term activities prioritized by crisis should be introduced. Now I'll come to another fact, that is the guidance of World Health Organization about social distancing. We know this is an oxymoron idea in an overpopulated country like Bangladesh and India. So instead of just saying
excuse me, I will have to ask you to conclude your presentation within a minute. Thank you.
Yeah, sure. I'm about to finish. So as I was saying, this social distance idea in Bangladesh is an oxymoron idea. So instead of just saying that implement the guidelines, we should say how an alternative approach can be taken, like introducing more safety equipment, and these steps need to be taken by the government. And we need to know how to fight with limited resources, because Bangladesh is a developing country. It will be, and also as for the India, it is an emergency developed country. So in these cases, government, they need to come forward and take in socialistic aspect. Last not the least, we say that united we stand, divided we fall. So we need then collective actions. Government, international, and local suppliers, consumers, everyone should work in solidarity to come out of this COVID-19, because this pandemic is affecting everyone, even the world. So, and unity steps and programs need to be taken. Well, with this, I'm going to conclude my presentations. Thank you for hearing me out, and thank you for staying with me for this 20 minutes.
Yeah. Thanks a lot, Bushra, for your wonderful presentation. So I'll be requesting you to turn off your screen sharing, please. Yeah, thanks. So now I will be proceed towards our last presenter. So the last paper is authored by two students of Department of Law, University of Dhaka, Tanvir Ahmed Fahim and Maruf Hassan Tomal. So I'll be requesting Tanvir Ahmed to present his paper. Thank you.
Good morning, honorable panelists, and thank you, honorable hosts. And good morning to all my fellow presenters this morning. Today, I am Tanvir Ahmed, student at the University of Dhaka, Department of Law, and I'm at my 4th year of law, and I shall be presenting a paper titled Balancing Conflicting Public Interests in COVID-19 and How States Parties Uphold Certain Rights over Others. I shall request the host to allow me to turn off my camera because due to rain, there are certain internet issues, so that I can present flawlessly.
Yeah, sure, please.
Thank you. I shall also turn on my screen share. Is my screen visible?
Yes, it is. Thank you.
Yes, thank you. Firstly, I shall start with a quote from Sir Humphrey Waldock, where he stated that in Lawless versus Ireland, that a government's discharge of responsibilities in maintaining law and order is essentially a delicate problem of appreciating complex factors and of balancing conflicting considerations of public interest. Our hypothesis for this paper is that during times of public health emergency, states prioritize the right to health and the right to life over the rights to expression, assembly, education, and other qualified rights. Our main objective is to establish that in the digital era, disinformation is one of the biggest hurdles to ensuring the freedom of expression, and to provide that during an emergency, right to life and the right to health triumph all other qualified rights, and that to establish that during times of emergency, the authorities are better judges of a crisis rather than the courts. Now, moving on with my paper, if someone had told us on the 1st of January 2020 that our whole way of life would be brought to a standstill by an enemy we could not see with the naked eye, we would call that person crazy. However, this is exactly what happened this past year, and we are still coming to terms with what has happened. The COVID-19 pandemic has swept across the whole world and has disrupted our whole way of life. In order to uphold human rights in any society, it calls for the existence of predictable normal situations. And the COVID-19 pandemic is by far the most unpredictable and unprecedented crisis the world has seen in the modern age. Unprepared, scared, and bewildered, the pandemic exposed what rights matters most: life, health, and access to basic necessities. During such a period of undocumented crisis, it is the responsibility of each individual state to take the most appropriate decision to uphold and balance human rights. And this paper focuses on that conflict and what states have done to balance such conflicting public interests, and how states' action need to be tailored to its own problems and circumstances. In order to define an emergency, it must be understood as an exceptional vesting of powers in the executive that would or should normally belong to the judiciary or even the legislature. However, among all nations have provisions specifically tailored for emergencies, and there is a specific international instrument which governs the restrictions and limitations of different civil and political rights in an emergency situation, the Syracuse Principles. This discussion points out to the direction that in the same state, the paradigm of various rights shift drastically, giving the sense of two states in a single one. The freedom of expression is a cornerstone of democracy, upon which the very existence of a democratic society rests. Indispensable for the formation of public opinion, it represents, in short, the means that enable the community, when exercising its options, to be properly informed. Ergo, it can be said that a society that is not well informed is not a society that is truly free. The right to freedom of expression is broad and inclusive and encapsulates the freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers and through any media, offline or online. The right to freedom of expression can be termed as the voice of all other rights. Without this particular right, no other right is free to be heard. This right has been ensured by numerous international instruments and national legislature, but one thing which they all have in common is the limitation on this right, which results in it being termed as a qualified right. Especially during times of emergency, it is necessary that in the interest of national security, maintenance of public order, public health, and social harmony, this right is to be curtailed. But in the 21st century, where lies spread faster than the truth, the states have a bounden responsibility to make sure that the general people are not misinformed, misled, or misused, particularly during a time of an emergency. The freedom of expression may be restricted only in accordance with Article 19, Clause 3 of the International Covenant on Civil and Political Rights, which requires all restrictions to be provided by law and to be necessary for the legitimate aim of respecting the rights and reputations of others and for protecting national security, public order, or public health and morals. The COVID-19 pandemic witnessed the rise of anti-mask movement, anti-vaccine movement, the rise of conspiracy theories, and much more. Even though this may be treated as trivial or even comical to many, the impact is widespread and long-lasting, since there are people who still believe to this day that the COVID-19 pandemic is a hoax, even after 3.8 million people are no more. The WHO has noted the emergence of what it calls an infodemic, which involves the rapid spread of information of all kinds, including rumors, gossip, and unreliable information. In a speech delivered at the Munich Security Conference on 15th of February 2020, the Director General of the WHO noted that fake news spreads faster and more easily than the virus, and is just as dangerous. Truthful information can be labeled as fake news and delegitimized. The European Commission has defined disinformation as verifiably false or misleading information that cumulatively is created, presented, and disseminated for economic gain or to intentionally deceive the public, which may cause public harm. In this 21st century, after the onset of the pandemic, it can be seen that the disinformation is a new evil after the onset of this pandemic from January 1st. From the beginning, we have heard numerous instances where people have resorted to unscientific, illogical, and ill-founded causes for and remedies to the pandemic. This not only causes mass confusion, but also mass unrest. Large tech companies are not the reliable entities we had hoped to bank on for keeping us safe from such disinformation. As a result, it is for the authorities in power of each individual state to determine the limitation on free speech in purview of its facts and circumstances. Starting from downplaying the virus and calling it a flu to protesting against vaccination, till date, the media has always played a pivotal role in steering the emotions of the masses, informing and misinforming them. The power of free speech cannot be downplayed in any way, being a fire-wielding immense power. During such periods of crisis, when the whole world is living in uncertainty, fear becomes the most powerful tool for those wishing to raise anarchy. Disinformation not only confuses people, but it misleads them into losing trust in the state mechanisms, causing them to disobey state regulations and cause further disruptions. Amidst the rising threat to other human rights caused by such disinformation, several nations have opted to shut down the internet completely. While this may be a temporary solution to a long-term vast problem, this is not well received by the international community. The Human Rights Council has strongly condemned the shutdown of internets that intentionally and arbitrarily prevent or disrupt access to information online. Shutting down the internet is an inherently disproportionate response given the blanket nature of the act, which blocks multiple other users of the internet from other users. Now moving on, the freedom of assembly is like a vehicle to many other rights like the freedom of expression, and it is an indispensable part of a democratic society. This right allows us to voice our concerns on the streets and in front of our target audiences. Almost all changes in that have taken place throughout human history, the language movement of 1952, the civil rights movement in America, and countless other movements could not be conceived, and many other protests to come without the right to assembly. However, the COVID-19 pandemic brought us face to face with a new reality of social distancing. The SARS-CoV-2, better known as COVID-19, is transmitted from human to humans by means of air droplets or aerosols. In order to reduce risk of infection, there needs to be a necessary distance between two persons, which is impossible in an assembly. Furthermore, the fact that COVID-19 shares its symptoms with other common fevers and that someone who is infected can also be asymptomatic, it becomes much more difficult to assess by conventional measures whether someone is infected or not. The United Nations Economic and Social Council Syracuse principles on the limitation and derogation provisions in the ICCPR suggest that such restrictions to freedom of assembly must be in accordance with the law, including international human rights standards, compatible with the nature of the rights protected by the covenant, in the interest of legitimate aims pursued, and strictly necessary for the promotion of the general welfare in a democratic society. An interpretive body of the UNHRC commented that such a right can only be curtailed when the restrictions are construed strictly and established convincingly, or there are exceptional circumstances. On May 25th, 2020, George Floyd Jr., an African American, was murdered by a Minneapolis police officer during an arrest. This led to a huge public uproar all over the world, which led to people coming to the streets and protesting against the violent crime. Even though this assembly was morally justified, it was not logically justified, since this raised the risk of infection and death rates in the USA significantly. As you can see, that there have been mass gatherings throughout the pandemic, despite the grave risks, as have been the greatest example in India, where there have been elections held, Kumbh Melas, and other celebrations throughout this pandemic. However, the sad reality soon hit them hard. This graph clearly shows the alarming and astronomical rise in infection rates and death rates in India, which surpassed all other expectations around the world. And on May 23rd, 2021, the highest number of deaths was recorded in India to be 4,896, and the infection rate of May 6th, 2021 stood at 414,433. Such horrifying consequences are the result of the people's ignorance towards the pandemic and towards not listening to what the world order is saying. Even though this is a tragedy throughout the whole pandemic, we still need to learn what we should do in this situation in order to preserve ourselves so that we can live another day. Amidst the pandemic, regions like Guatemala, Romania, Georgia, etc. have all sought derogation from Article 21 of the ICCPR and Article 11 of the European Convention on Human Rights. And these regions have used public health and life of the nations as grounds for derogating from those articles. So different states acting differently may raise questions about rights being infringed upon where more restrictive measures have been invoked. The margin of appreciation refers to the latitude allowed to the member states of the European Union in their observance of the convention, that is to say, the European Convention on Human Rights. It is a mechanism to respect governments on their discretion while dealing with the problems which are endemic to the country's circumstances. Now moving on to the next slide. The pandemic has shown that in times of crisis, time and again, above all other rights, education is always the one to suffer the most. However, this pandemic was different since the global education system suffered. Schools, colleges, and universities all over the world were closed off and education stopped in its tracks. However, soon afterwards, people came to terms with the pandemic. Educational institutions started online learning sessions, and that has been continuing ever since. Many schools and colleges were open even during the pandemic, but but they also had to suffer because of their actions, especially in the UK. The right to education is recognized by various international and regional legal instruments. Even though this is a basic necessity, basic right, during times of emergency, it is usually the first one to face the impact. According to UNESCO, 1 year into the pandemic, close to half the world's students are still affected by partial or full closure of schools, and an estimated 40% of the poorest countries fail to support learners at risk due to the COVID-19 crisis. Although remote learning has been encouraged by the international realm, developing countries, even developed countries, have struggled with the accessibility issues concerning online education. A government has to build a separate infrastructure so learners get equal opportunity to access the materials of online schools. Otherwise, the whole initiative could be deemed discriminatory and hence illegal. For poorer countries, this is a worse reality. The nature of the virus does not only risk the safety of the students and the teachers, but also the staff, guardians, and all those related to the functions of the institutions. Another major issue arose due to the disparity in the internet access and infrastructure necessary to hold the classes online, particularly due to the lack of training, which played a key role for many people since the platforms available at the time were difficult to operate or use. However, the problem has been resolved with newer updates. And finally, it must be said that the education suffered the most in nations where the lack of stable and reliable infrastructure to enable students to attend online classes. In regions where electricity is scarce and internet networks poor, students were simply in the blackout zone. Such disparity led students to demand the reopening of classrooms since there was an unequal access to the right to education. However, there was little that could be done since poor infrastructure could not be made stronger by diverting
Sorry to
resources.
interrupt you, Tanvi. You have 5 minutes to conclude your presentation. Thank you.
Thank you very much. As I was saying, it must be said that little could be done to improve the infrastructure by diverting resources, especially when there were greater interests at stake. The pandemic has seen the worst forms of trade blockade and travel bans in recent years during peacetime. However, almost 1.5 years after the onset of the pandemic, trains, planes, and ferries are all fully operational and people are trying their best to conduct their businesses as they used to. But this does not mean that all industries are fully operational and have recovered completely. The hospitality sector in particular has suffered immensely due to the devastating fall in tourists and customers. Major tourist cities and destinations have seen a huge drop in businesses due to the pandemic. Most people in those regions base their whole livelihoods on incomes from tourism. However, despite suffering huge losses in revenue and fall in GDP, the borders remain shut and the hotels remain closed. For the greater good of the greater number, this was necessary. From the onset of the pandemic, all sectors of the world economy have been hit like never before. Numerous nations have halted imports and exports, blocked trade routes, and brought the whole world economy as we know it to a standstill. The hospitality sector industry is one such sector which has been hit the hardest and is still coming to terms with the pandemic. Major tourist cities and destinations have seen huge drops in businesses due to the pandemic, and the impact on restaurants was also prevalent as they were completely closed off. and operating only online, giving takeaways, or operating at half capacity for a limited time duration throughout the day. Even though many say that due to takeaway services and restaurants, the restaurants have stayed afloat, this is only barely true. The complete closure of certain sectors of work may seem rational given the infectious nature of the coronavirus. The policy decisions have caused much distress to the work employees. During a public health emergency, for social gatherings, the key aspect of any hospitality venue is the main obstacle. It becomes increasingly difficult for the executive to prioritize the right to work and occupation over the right to health and right to life. Large gatherings that take place in restaurants, hotels, and resorts can exponentially increase the infection and death rates and spell disaster, especially due to the influx of foreigners and the diseases that come with them. Health and right to life being the key concern. Lastly, it must be said that even though there have been huge economic losses suffered as a result of the closure, it was necessary in the interest of public health and keeping the pandemic under control. Lastly, I shall say that throughout this presentation and in our paper, it has been shown that during times of crisis, when states are pinned against the wall, when they have to decide one right over the other, right to life, right to health, and the right to basic necessity triumphs all other rights. It is true that there have been huge sufferings and huge losses, and people have suffered immensely, which have not been covered in this paper, and it is still not possible till this date, till the pandemic is over. It is still true that as long as people are living, people are well, people are receiving the basic necessities, they can live another day and fight. In 1976, the court held in Handyside versus United Kingdom that, by reason of their direct and continuous contact with the vital forces of their countries, state authorities are in principle in a better position than the judges to give an opinion on the exact content of these requirements, as well as on the necessity of a restriction or penalty intended to meet them. In situations unprecedented by the world at large, it is up to the individual nations themselves to uphold the fundamental human rights and balance its conflicting public interests. Each nation's issues are individual to its own, and it is not possible to compare it to any other nation, nor should it be compared to any other nation. And with that, I conclude my presentation. Thank you.
Thank you, Tanvir Ahmed Fahim, for your presentation. Could you please turn off your screen sharing, please? Yeah. Thanks a lot. So that concludes our presentation. Now it's time to hear from our respected panelists. So first, I would be requesting Barrister Imran Abdullah Siddiq, sir, to comment on the papers. Thank you.
Thank you, Riza. Assalamu alaikum and good morning to you all. I think we've all had the opportunity of listening to 4 very good papers being presented today. It was a pleasure to listen to all of them. And I really don't mind spending my Friday mornings listening to papers as good as the papers that we've just heard being presented. So I'll first comment on the last paper that was just presented, the paper which is authored by Tanvir Ahmed Fahim and Mr. Maruf Hassan Tomal, which is on balancing conflicting public interests. And this paper, I thought, raised very interesting questions as to the extent to which the executive has to balance between countervailing public interest considerations during a pandemic and whether one group of fundamental rights may be balanced off against another. These are very difficult questions, and there are very few judgments of the superior courts which deal with these issues. And this paper rightly highlights the growing problems of disinformation, not just in Bangladesh, but across the world, its impact on life and security, and the need for caution in the exercise of free speech. However, what I was expecting and what I missed was a more detailed discussion on the emergency provisions in the Constitution. The reason why I raised this issue is because last year, at the height of the pandemic, there was a debate about whether emergency provisions in the Constitution should be deployed by the executive to deal with the pandemic. Thankfully for all of us, emergency was not declared. And now that we are more than 1 year into the pandemic, it can safely be said or presumed that it won't be so declared. But questions still remain as to the legality of the restrictions which have been imposed in the form of lockdowns to combat the pandemic. Some of my colleagues in the bar, they have argued that emergency proclamation is the only lawful way by which lockdowns may be imposed and enforced. So that is an issue that could have been discussed in the paper, because when you have an emergency, or when you talk about having an emergency, automatically you have the questions arise as to whether some fundamental rights are more important than others, whether we can choose between fundamental rights. And if we were to do so, how should we make a decision to that effect? My views are on this particular position are quite forthright and clear, straightforward, and that is that the emergency provisions in the Constitution should not be declared, and it is not necessary to deploy them for the purpose of imposing lockdowns. In fact, I take the view that the Third Amendment provisions in the Constitution, by which the emergency provisions were introduced, they are fundamentally at odds with the basic structure of the Constitution, because fundamental rights are at the heart of the Constitution. They form part of the basic structure of the Constitution, and the emergency provisions which were introduced by way of amendment chip away at the basic structure. But we could also have a discussion on whether pandemic falls within the definition of internal disturbance in Article 141A of the Constitution, which would warrant the imposition of an emergency. To my mind, I mean, to treat a pandemic as an internal disturbance is to resort to semantic gymnastics. Internal disturbance was never contemplated to cover pandemics, and therefore, I mean, the question of imposing a lockdown by deploying the emergency provisions, in my mind, would not be appropriate. So when we look at the provisions in Article 141A, 141B, and 141C, automatically questions arise whether the fundamental rights that are suspended during emergency, for example, Article 36, the right to free movement, Article 37, freedom of assembly, Article 38, freedom of association, Article 39, freedom of speech, and Article 40, the right to the freedom of occupation and profession, whether these rights are more important than other rights, and whether these rights can be suspended during lockdown without declaring an emergency. Now, we don't have many laws in our statute books to deal with the pandemic-like situations that we find ourselves in today, but there is one law, and it is the Infectious Diseases Control Act 2018, and we could have had a discussion on this particular law because there are certain provisions of this law which allow lockdowns to be imposed in specific areas of the country. It does not contemplate countrywide lockdowns, but it allows lockdowns to be imposed in specific areas or sections of the country. So the question is whether use of that law would allow the government to combat the pandemic without suspending fundamental rights. And I think it can be said with some degree of certainty that this law, which was in fact invoked in issuing the circulars regarding lockdowns in April last year, has proved to be useful in providing some sort of framework for imposing lockdowns and regulating movement and imposing restrictions on general behavior and movement of citizens. So that is an area which perhaps could have been discussed by the authors when discussing the possibility of grouping or stacking one group of fundamental rights against another group. The second paper that I would like to discuss is the paper on food security. Now, this paper was an eye-opener for me personally, because in the last 17 years, in the last 17 years of my practice in the bar, I have not had the occasion to read up on food security or to study it. And this was a new area for me, totally. And I found Padma's insights into the possibilities of cross-sectoral and cross-country collaborations very interesting and very reassuring. But from the point of view of the lawyer, I thought that maybe we could also have a discussion on what is the appropriate legal framework for ensuring food security. Because there has been much discussion about a dearth of laws on protection of agricultural land, on laws which protect equitable distribution of land, on laws which protect farmers' rights, on laws which protect generally the right to food. So perhaps we could have had a discussion on the legal framework that needs to be developed to ensure that farmers' lands are not grabbed, fertile lands are not grabbed, and farmers' lands are not acquired for developing private economic zones, for instance. We have had assurances from the government in this regard on several occasions, but there is yet to be a law which specifically deals with the right to food security, and that is a very important area that we must deal with. The two other papers were on labor law, and both of them contained a very comprehensive discussion of the labor law regimes in Bangladesh and India. And with regard to the first paper which is presented, that was by Rubaida Jamila Manobi, that contained a very important discussion on the effect of the pandemic on workers and how the international labor standards could be adopted in dealing with the consequences of the pandemic. But I was just wondering whether we could have had a discussion on vaccination, whether employees could demand or workers could demand vaccination, and whether employers could demand that workers should be vaccinated before entering the workplace, because there is a debate, particularly in the United States, regarding vaccination, whether employers can bar employees who have refused to be vaccinated, or whether employers can just require or grant incentives for employees to be vaccinated. And it has been held that Equal Employment Opportunities Commission laws are not violated if the employer requires the employee to be vaccinated. So we could have had a discussion on this aspect of the on this particular aspect as well, because vaccination is the debate around vaccination is a continuing one, and although the vaccination rollout program in Bangladesh is quite slow, but this is an issue that we cannot avoid, given that we are clearly in it for the long haul. The last paper that I would like to discuss was the one which is delivered by Bushra Haq, and she rightly suggests that the laws should be enacted to deal with the emergency situation that we find ourselves in today, because the Labor Act was not meant to cover pandemic situations as we find ourselves in today. Social distancing, she says, is an absurd idea in a country in Bangladesh. That may be so, but compliance with legal provisions is not. And she's already referred to relevant legal provisions like Section 52 and Section 56 of the Labor Act, which relates to prohibitions on overcrowding and prohibitions for providing adequate ventilation. And if these provisions are complied with, then to a large extent, social distancing measures would be upheld. But one point that could have been made in that paper was the role of the Department of Inspections for factories and establishments. And given that there are sufficient legal provisions in the statute books, the question remains is to the extent to which they're being complied with. And since we have a specific provision in the Labor Act, Section 319, which allows for inspections to be conducted by the Chief Inspector and other officials, perhaps we should advocate for a greater implementation of that provision. because if during the pandemic there are regular inspections by the relevant department to ensure that social distancing measures are being complied with, this would go a long way towards ensuring worker safety. So those were my brief comments on all four papers. I really enjoyed hearing all the papers being presented, and I thank you, everyone. Thank you very much.
Thank you, Barrister Siddiq, for your valuable comments. I'm sure that our presenter will be greatly, enriched by your comments. So I would now be requesting Professor Ridwanul Haq, Professor at University of Dhaka, to share his comments. Over to you, sir.
Thank you so very much, Raja. Please stop me if I'm not audible or that audible. First of all, I would like to congratulate all the presenters for their lucid and wonderful papers. I really enjoyed listening to them. And let me be very honest and frank. It's indeed a pleasure to see that master's or fourth year final law students have presented such well-written and well-argued papers, and with difficult topics such as food security, as well as the impact of COVID on the labor rights. So I'd go by one after another, so starting with the first one, which is presented by Rubayat and Amanullah Al-Aman, it's a nice name. So it's basically on the impact of COVID-19 on the labor rights in the industrial sectors of Bangladesh. The paper is broadly about social legal interactions. So, I mean, examining the impact of COVID-19 on the breadth of rights of the workers, but through a lens of legal regulation or the lapses in the regulation, and a little bit mundane in terms of describing all the laws, rather than critiquing the gaps in the law. This is one thing. However, excuse me, please. A good aspect of this paper is the statistics that have been used, and so it has been a kind of empirical research which is lacking in the research landscape in Bangladesh. So I congratulate the two authors on this aspect in particular. So I couldn't see the full paper. What I have gone through is the abstract, and what I have done along with Mr. Siddiq here in this session, just I was minutely listening to you. So Mr. Siddiq has given his comments, and that's also that's echo my voices too. So I'm not going to details in this respect, but I'd like to draw the attention of the two authors as well as other authors. I'll be coming to that in a while. To the style of research. So in your research, try to particularize or pinpoint a specific area. That would give much ease to you. Say, for example, you're dealing with the whole industrial sector. So why not picking up a specific sector? Say, for example, agriculture. Say, for example, garments export. Or say, for example, we are talking about workers, and maybe taking up the case of the returned migrant workers. And that would be an innovative area. So the best thing to do for a young or an early career researcher is to be very specific rather than taking up an unmanageable area, and to be innovative within that technique. So these are the practical advices, and I do not really know, I mean, what's the end target of this exercise? Are these presenters or the students are looking forward to publishing their work in a platform? I don't really know, or it's simply an exercise, academic as well as intellectual exercise, and nowhere to go from here. Or it's upon the discretion or interest of the individual presenter to take it further as a law review article or something else. So it depends on this actually. So to what extent you will develop your paper, and a little bit about stylistic things. Say for example, if it's aimed for a publication, it's important to be perfectionist. It's important to be careful. So I have gone through the slides of all of you. I've seen that just a little more care or one or two readings of your own slides could have improved the style of presentation a lot. I'm not talking about oral presentation. I'm talking about the slides. I mean, the way you have written. Okay. Let me give an example. Give you an example. For example, maybe I'm not specifying which paper is this. Say, for example, you were writing article 5, 10, 15. So why not articles? You know that this is articles, plural. You know that. So what's the problem here? The problem is you didn't give enough time of these to these 14 or 15 slides. So this is important. And one thing is, one more important thing is you have to be very careful about citing law, because law changes every time. Say, for example, I'm working with India and you're citing a law, but you haven't checked whether the law has been updated or the reference you're making has been updated or not. And also, it's important to be within the, practice of citing using law. For example, I have seen a word here, something like Article 176 of the Bangladesh Labor Act. So we do not use the term article to describe a section of a statute. We use the term article to describe a section of a constitution. Right, so this is important. So let me now take up the second one by Padma on food security. This, to me, I have a little interest in consumer justice, and so I once taught this subject at Premier University Chittagong. This is fantastic. This is very, very interesting subject because it goes to the life of the people, to the lifestyle of the people, and to a continuing problem with which we are struggling in our society, in our respective society, either in Bangladesh or in India or in Pakistan. So much of consumers' rights are violated on a daily basis that it's simply impossible to enumerate or list. Anyway, so this is a fantastic chapter once again, but I have very little expertise on the very topic food security overall. But the problem with this chapter or with this draft paper is scope is too broad. It's about South Asia. It's about the peoples of South Asia. So what do you mean by South Asia? At one point, Padma used the term SAARC. So are you meaning SAARC countries by South Asia? Or you are meaning simply Bangladesh and Nepal and India, for example? Because I've seen some references to India and Bangladesh, and you are from Nepal, as I have seen. And in the statistics level, you have simply quoted a piece of statistics from United Nations information or data, where you have cited Afghanistan. So this is all about confusing. And for you, the way you have sort of presented the methodology is also a little difficult to follow, to pursue for the purpose of your research. So you have to redefine your methodology because you're taking up South Asia. So how do you do that? So my advice would be South Asia would be too big a topic to cover. So rather you do better to be specific. Say, for example, a comparison between Nepal and Bangladesh, or between Nepal, India, and Bangladesh, for example, major or most notable countries. Or it might be just four: Bangladesh, India, Nepal, and Pakistan, something like this. That would give you an advantage, a kind of control over your own research. So this is important. And looking at your paper, it seems to me that you have given some recommendations on a random basis, and some recommendations are maybe problematic or maybe totally unimplementable. Say, for example, you have asked how you have recommended for the engagement of or the appointment of migrant workers, returned migrant workers. You didn't write the word there, but you said that you meant returned migrant workers. Fantastic recommendation. But how are you sure as a researcher that is gonna work? Apart from that, so how is it relevant? Or to what extent it is relevant to put all these recommendations within the framework of your research scope. And for all the presenters, not only Padma, all the presenters, and also Rubayat gave some recommendations. My strong position, and I'm notorious for this, is that no recommendations, please, in your research paper. So you are a researcher. You are not a commission. You are not an information commission, or you are not a government employed, appointed commission to give some recommendations for the government to implement. Or you are not writing a policy paper for an NGO that you make a list of recommendations. In a research, there should be no recommendation. And once again, I'm notorious for flagging this suggestion to all the researchers. It's a peculiarly South Asian trend or Bangladeshi trend amongst the researchers, even in PhD research or MPhil research, to come up with a list of recommendations. And I've seen people to include a whole chapter on recommendations. No, not a single recommendation in a research paper. So if you are serious enough to take these points to the benefit of the policymakers, you can do the job by simply rearranging your phrases, your words, your sections, your writing. Do not use the term recommendation. You just critic. You just locate, find out the gaps where you see there is a gap, something like this. Now, to move on to Bushra Haq's paper. Yes. So Bushra's paper was on Bangladesh and India. And what is the broad title of the paper? Let me check. Sorry to bother you. Yeah, labor law in Bangladesh and India. Yes. So fantastic. So that's what I like. So this area is focused. So Bushra proposes to work on India and Bangladesh, and definitely there is a comparison. So as a startup, this is a good attempt. And yes, Bushra has very rightly analyzed the law and their impact on COVID-19 and given a kind of rationality. Why comparing between India and Bangladesh? That's fantastic. Every reader would ask, why this person, this guy, this researcher is comparing between Bangladesh and India, and with regard to the labor sector, for example. So a first question that would come to the minds of an engaged reader, whether this comparison is time befitting, or is she comparing the two comparable things, or is she comparing between an apple and comparing an apple with an orange, something like that. This is a fundamental question for any comparative researcher. So I like the approach to describe the rationality. But in such a research, you will also have to mitigate the objections of comparison. So what are the dissimilarities between Indian responses to COVID, or between Indian COVID-19 impact on the labor sector and that of Bangladesh, something like this. So you'll also have to focus on that. This is called mitigating the objections. But once again, you have fantastically given an introduction for the comparison between India and Bangladesh. I'm not going to say more about that. Overall, this is a good paper, and I liked it. And now coming to the last and the final paper by Tanveer, and there's one more author. And yes, Tanveer has also written a fantastic paper, and his presentation was also catchy and attention seeker presentation. So I had to give extra attention to this because I have some interest in constitutional law, and this is the only paper, in my opinion, that implicates constitutional governance, the rule of law, and the million-dollar question of balancing the interest or balancing the competing public interests. This is a fantastic title, and I would say this. So it really reaches to the very core of my urges for a paper on COVID impact on constitutional rights. Mr. Imran Siddiq has very elaborately and very insightfully critiqued as well as appreciated Tanveer's paper, and all are valid points, and particularly since it's all about balancing, it's a constitutional balancing. And there's a fantastic book on balanced constitutionalism. I don't know whether you are aware about this, and written by Chandrachud, who is a grandson of famous Justice Chandrachud from India, and the son of current sitting Justice Chandrachud. So yes, balancing constitutionalism. Constitutionalism sometimes should balance between competing interests. And Chandrachud's book was about balancing between legislature and the judiciary. And here is balancing about three different organs of the state also, with reference to the COVID-19 constitutional implications. Fantastic, well done. But I wonder, and standing on the same footing with Mr. Siddiq, that a little more, not only a little more, perhaps it's missing analysis, inclusion of an analysis on constitutional health emergency. And I don't know whether you are aware of this. I have written two small pieces in a German platform, Verfassungsblog, simply means constitutional law blog, purely on COVID-19. In the first piece, I went for constitutional emergency, saying that that is the best option if you really mean to handle COVID legally, lawfully, and in a way that is compliant with the fundamental rights of the people. There are also objections that emergency is not the solution, or it might have consequences. But Mr. Siddiq has shown that the existing statutes have limitations in effectively dealing with COVID-19. And he is absolutely right in saying that the 2018 Act is geographically limited, or in terms of the enforcement, it's more focused on the civil surgeons. But you sometimes need a statewide policy for that. So you can't probably avoid one or two paragraphs on emergency provisions and the lawful handling of COVID-19. And one important factor that remains unanalyzed here is the doctrine of proportionality. We all know that the state has power, the executive has prerogatives, even in the absence of emergency, to do an emergency measure like this in the greater interest of the public life. So we all know that. But at the same time, we are saying that because of this, some other rights are being marginalized. Say, for example, to give preference to the right to life, you are marginalizing the children's right to education. If I consider that right to education is a right. Now, given that, even accepting that the state has this right to prioritize or to give preference to one right over the other right, given that, there is a question of exercising that preference. It's a question of proportionality. To what extent, I mean, the government is right, for example, in putting the right to education at bay for 2 years, for 3 years? Is that action proportionate to the demand coming from the right to life of the people? So say, for example, the question is, could the schools, colleges, and universities be opened some 6 months ago from today? Right? Initially, they were closed. That's fine. But to what extent? How long? So this is a question of proportionality. So this is completely missing. You can't avoid this, in my opinion. And one thing is also very interesting here in this paper is giving a priori assumption that right to life and these rights are very important, and the government or the state has a right to control this, or sorry, not to control, to give a preference to these rights over any and every other rights. This is a complex phenomenon. You have to be very critical, methodological, and jurisprudential and argumentative. You can't say so. Say, for example, right to education. So is there a scope for us to see right to education as part of right to life? If yes, then there are two right to life. One is right to life proper, the right to be immune from or to be protected from the virus that's going on, and also to carry on the right to life, which is education, right? So, but on the other hand, you know that right to life is not, I mean, uncontroversially established as a constitutional right? So we are all saying that people's right to education. Right to education is hampered, jeopardized. The first question is it a right? You also have to dig deep into these questions. And if you take that, no, this is not right, this is a social right, okay, the implementation of which depends on the state resources, or the discretion goes to the state, then once again, the proportionality concept comes in. So a number of things here that you have to look into. And globally, there is a now tone on the COVID-19 impact on COVID-19's impact on human rights. You have to look at those things, particularly from theoretical perspective, to what extent these measures are correct, or these rights can be given preference. And so how do you balance the competing interests? And you have to question the executives ability, agency to do this balancing in a single hand. Say, for example, I am referring to the absence of the judiciary in this exercise, for example, and also absence of the parliament in this exercise. Okay, for example, if you look at the legislation, the number of statutes that have been enacted in 2020, starting from March down to December, around 22 or 23 legislation, there was not a single legislation, not a single law on COVID-19 management. And these things have not been decided in Parliament. So it's purely the executive which is giving the preference, in your own word, to few rights, particularly the right to life, over the other rights. So you have to question and examine that thing, because it's related to the separation of powers also. So thank you very much. And I apologize for not doing the proportionality kind of thing myself in evaluating the 4 papers. Probably I've given much time to the one that suits my interest. So it's an opportunistic kind of activity on my part. So sorry for that, and I bear with all other presenters. And once again, congratulations to all of you for your nice endeavor. Thank you.
Thank you very much, sir. I think it's always a pleasure to listen to your thoughts on constitutional law. So I'm sure that the presenter will be highly benefited by that. Just to quickly respond to one of the queries you had about the ends of this paper, so we are planning on publishing some selected papers after going through proper review process. So yes, there is an opportunity to incorporate these comments and feedbacks, and then after a thorough peer review process, we will publish some of the selected papers. So just to take permission from the panelists, should we take a few responses from the presenter before I go to a short Q&A session? Pastor Siddiq, Professor Ridwan.
Yeah, that's fine.
Yeah.
As you deem fit.
Yeah, so I'd be requesting the 4th presenter, if you have anything to respond to or any question towards the panelists, you can turn on your camera and ask them, but please be brief on your questions. If you have any questions or respond towards the panelists, you can do it now. 4th presenter, I'll be requesting you to, if you have any questions or response, you can do it.
Can you hear me?
Yeah, yes.
Okay. Thank you very much. Actually, I wanted to say that we actually more wanted to work on scrutinizing the labor law with the impact of the COVID-19 situation. But thank you for your observations. We will of course incorporate with the vaccination, and we will also change some terms as you have said. And thank you very much for your observations. Thank you.
Yeah.
Thank you.
So Padma, do you have anything to respond to, or you have any question?
Sir, I do not have any specific questions, but I'm very thankful for our respected panel members for giving a critical review on my paper. And now I know about the shortcomings on my methodology or topic selection. And also my paper lacked the legal framework that I should have addressed. So taking into account all those recommendations, I promise that I will further improve my paper, and thank you so much.
Yeah, thanks a lot. Bushra, anything to respond to?
No, sir, I don't have any specific inquiry, but thank you for all the feedbacks that were really informative.
Yeah, thanks a lot. Tanvir Ahmed Khan. Any question towards the panelists? Tanvir? Yes, could you please unmute yourself and if you have any question? Right. So thank you. We're having some issues with the network. So now I'll be going for a very short QS session. We're slightly past our scheduled time. So with the permission of the panelists, I'll be taking a few comments as we have joined by a few distinguished faculties and researchers from around Bangladesh and from outside Bangladesh, from abroad as well. So if anyone has any question towards the presenter or panelist, you can another ask the question. The floor is open. Thank you. Please turn on your cameras and unmute yourself and ask the question. Yes, we have one question from Vijay Prasad Jaswal. Yes, Vijay, please.
Yes, thank you so much, Rizal, for giving me a chance to ask the questions. I'm not going to put forward like observations, and it's very similar to one of the panelists, Professor Zidaul Haq. I had a very similar opinions in terms of recommendations, while in terms of like phrasing your papers or research topic. I heard like two papers about the Bangladeshi labor law, but so my concerns out up to anyone can respond my query. I didn't find any slides where you have mentions about the compliance of Bangladeshi legislative measures in terms of labor law with the international standards. If that is the limitations of your papers, you can easily escape it. But if that is a part of research, because when we say, I mean, any measures that either the India or either the Bangladesh is a party to the international ILO instruments, at least it's better to show somewhere where is a gap. So that's a one thing. And second is is for Padma. In fact, so when we talk about the regional food security arrangements, have you visualized any particular institutional structures out of these three that you cited that we have? Whether those three are inadequate, or you have like pictures that this, if we create these institutions with the help of, if we assume a SARC members as a area of your paper, have you thought of any, have you thought from that perspectives or not? Yes, that's all. Thank you.
Okay, Reza, this is me, Professor Jamil.
Yes, I just about to request you. Yes, please, Professor.
Thanks, Reza. I'm almost with my previous speaker, Vijay Jaishal, if I'm not wrong in pronouncing his name. If I'm not wrong, sorry for that. In line with Professor Dr. Ridwanul Haq, as well as Mr. Imran Siddiq, most of my comments are in line with them. That's why I will not repeat, because we are already under time constraint and we are scheduled to appear the Jummah prayer. However, something should be uttered, which I observed very briefly. Our first speaker, that means Amanullah Aman and Rubaiyat Manbi, they have ultimately discussed their paper on labor law and COVID-19 situation in Bangladesh. Though it has been already observed by both of our panelists, especially by Professor Dr. Ridwanul Haq, that the title is too generic. So yesterday also I said the same thing. Your title should be focused on a particular field, rather than it should be very wide and broader, that labor law. Yesterday, there was one of the participants, Nabila Ruwaiyat. So she has also dealt with labor law and its relation impact on COVID-19. However, she has ultimately narrowed down her scope by discussing RMG sector, for example. So it's better for you. The suggestion will be, ultimately, you will take the suggestion or not, it's completely upon the researchers. However, it's my suggestion. It would be better for you if you would really like to publish somewhere in future, you will confine the title in a specific arena. And secondly, in your abstract, as well as if I am not wrong, I didn't find anywhere in your PowerPoint slides that you didn't mention, though you have mentioned in repeated way several times, Labor Act 2006. However, Labor Rules 2017 perhaps has not been uttered, or it was not incorporated in your slide. So again, better for you, if it is lapsed, you can insert that one. For my observation for the second speaker, Padma Rizal, her title was Impact of COVID-19 Pandemic in Right to Food and Regional Food Security of South Asia. Though we are under time constraint, nonetheless, at this point, I really would like to request Padma, you are one of my UMSAILS students, so you know me, sometimes I do this thing very often. So Padma, can you just go back to your slide number 5?
Okay, ma'am. Should I share my screen or?
Yeah, it would be better if you just share your screen so that every participant can understand and comprehend what I would like to say now.
Is it visible?
Yes, it's visible. Thank you so much for your cooperation. This slide, to me, is very important, however, at the same time, very complicated. Perhaps you didn't focus much on this slide. Since,
yes, ma'am.
Yes, since it's a very important slide to incorporate all the total entire theme of your title, perhaps if it is elaborated more, it would be better for the audiences to understand. So you are understanding so many arrows with so many boxes. So which is linked with what? It's a bit difficult for me to understand. So this is my observation one, ultimately in respect of slide number 5. Against the second observation is you are ultimately confining your discussion with South Asia. However, again, I am a bit confused. While you're ultimately, when you are just depicting your analysis on South Asia, you perhaps you have only cited 2 or 3 countries, starting with Afghanistan, Bangladesh, and perhaps Nepal. Obviously Nepal, because you are from there. It must be somewhere there. For me, when you are saying South Asia, why you are deducting the other countries from South Asia? At least you should rationalize if you don't incorporate those countries. Otherwise, better for you, since South Asia don't comprises of so many countries, to incorporate all of them. If not, rationalize why you are not, due to time constraint, etc. You can do it. Regarding third and fourth speaker, I'm very comfortable with, as I said earlier, comfortable with the comments with Professor Dr. Ridwanul Haq, as well as Mr. Imran Siddiq. I'm very glad to hear these 2 speakers, speaker 3, Bushra Haq, and speaker 4, that means co-author speaker, Tanveer Ahmed and Maruf Hassan Thoma. Glad to hear this one. So better to not spoil my time by saying anything on this topic. However, in one point, I don't agree, perhaps should not be said. Rather, I'm a bit not comfortable to accept the proposition of Professor Dr. Ridwanul Haq regarding what he said, insertion of recommendations in your paper. In my case, my PhD from University of Sydney, and it was kept in the rare collection, archive collection of the University of Sydney's library. I have given recommendation in my last chapter because I had an intention that recommendation part perhaps shed a light to the policymakers to give a reform if really they intend in future for Bangladesh. Though Professor Dr. Ridwan said that these kinds of recommendation, if it is a policy paper or something else, then it should be incorporated. That is very consistent. Recommendation part is very consistent for those papers. However, my view is a bit different, that if your article is not only for PhD thesis, if it's a mere piece of article, if you think your title demands something to recommend for the policymakers, you don't know where your article or thesis will be published. So if you put this recommendation in whatever form, in somewhere in your article or thesis, I think, it's my subjective view again, perhaps obviously Professor Dr. Ridwan will differ with me, you can do so. So despite some of the loopholes from our very young researchers, we cannot take all those things, but just like we will not find out all loopholes and ultimately give them something that we are not much appreciated by their papers. We are not much influenced, convinced by their papers. For me, as a young researcher, if I were there at your situation, perhaps, not perhaps, I'm certainly sure, I could not able to do like that. So given this context at your young stage, young researching mind, obviously, is there any loopholes, we will just better to ignore that one. Obviously, we will mention that one. That's why we are here. However, I finally thanks everybody, every young presenters who have courage, their spirit, and attach themselves with this platform. Thank you so much.
Thank you very much, Professor Jamila ma'am, for your valuable comments and encouragement. So we are running out of time. I'll take one more question. Tanvir wishes to respond to one of the panelists' comments. So Tanvir, if you could briefly respond to the comments. Tanvir Ahmed, fine.
Hello, thank you, Mr. Rezwar. Sorry I could not attend at that time because a baby was there. Thank you, Professor Jamila ma'am and Professor Ridwan and Professor, I'm sorry, I'm not able to catch the name, Professor Imran, Dr. Imran. Thank you for your comments. And I must say that it was a bit of a challenge that we took upon ourselves when we were discussing whether or not to pursue this paper, because it is intrinsically a very delicate task that we had to do when comparing which fact to consider and which to not. And in general, we realized that we could not limit our observations to a particular nation, but rather to be universal and to approach this as a universal, holistic approach to what states should do during pandemics. However, it is also subjective because the core aim is that state responses should be subjective to their facts and circumstances. Regarding the fact of recommendations, we did not think that we were able to recommend something on such a topic because we believe that recommending on a topic which people rarely even talk about balancing such complex human rights, we thought that it was better left to be unsaid. However, within our paper, we have expressed how during times of such crisis, even if such restrictions are imposed, they should be following the Syracuse principles and other conventions and other judgments that have been given throughout the times. Thank you.
Thank you, Tanvir. I'll be closing the session soon. So let me conclude this session by expressing my utmost gratitude to our respected panelists. Barrister Siddiq had to leave because of another meeting. Also, I'd like to sincerely thank Professor Ridwanul Haq sir for his time. And I would also like to thank the professors, colleagues, and researchers who joined this session. And of course, I'd like to congratulate the four presenters for their wonderful presentation and hope these comments and feedbacks will be helpful for your further improvement of the paper. So we have another session coming at 2:30 p.m. So I hope everyone will join the session. And with this, I would like to conclude this session. Thank you everyone for joining. Thank you very much. See you soon.
Thank you, Reza.